Your Honour, I represent the defendant in this matter. The Crown has entered 106 indictments against my client, and I apply under Section 590AA of the Queensland Criminal Code for a ruling that the evidence against my client in all 106 indictments be excluded. I would like to hand up to Your Honour a copy of my written submissions in support of this application. I will tender this. The facts of the matter are this. My client is a 15-year-old juvenile Torres Strait Islander. He was born on 15 January 2001. On 3rd of May 2016, my client was arrested by 2 police officers. Following his arrest, the officers began to question my client on the scene. At this point, my client had not spoken to a friend, relative or lawyer, or been informed of his right to do so. The officers then took my client in their car to 106 properties around the area and asked whether he had broken into those properties. Again, at this point, my client still had not spoken to a friend, relative or lawyer, or been informed of his right to do so. Following this, the police took my client back to the Brisbane City Police Station for further questioning. There, my client was sat in an interview room with a person we know as Donna. Donna was introduced to him as a support person and social worker. However, the actual identity of Donna is unknown, and so are her qualifications. What is known, though, is that my client had never met Donna, was not related to Donna, and did not choose for Donna to be there as his support person. Donna then told my client that in the interview to answer all of the police's questions and to answer them truthfully. The police then began to interview my client. My client made full admissions to all 106 indictments, which is the evidence in which the Crown relies. That is the interview which was recorded. My submission is this. The recorded interview of my client, which is the only evidence against my client, has been obtained unlawfully and transcends questions of unfairness. I make this submission on the following grounds. The arresting police officers have not complied with their obligations under the Queensland Police Powers and Responsibilities Act 2000 for questioning children. Namely, the officers have not, Namely, the officers have failed to comply with Section 421, subsections 1 and 2, which deals with the questioning of children. Before moving to the words of that section, I'd just like to point out that my client is clearly a child. He's 15 years of age, which makes him a child for the purposes of this Act. Now, could I please take Your Honour to page 5 of my submissions, which outlines subsection 2A of Section 421 of the Act. This subsection provides that an officer must not question a child unless before the questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child, in which that conversation may not be overheard. Dealing with practicality first. There is nothing in this situation that suggests it would have been impractical for my client to speak to a relative, friend or lawyer prior to questioning. There was no apparent urgency either on my client's behalf or the police's, and my client cooperated in all aspects of the interview. Further, the police made no attempt to contact a support person for my client, nor did they inform him his right to contact such a person. So given that it was practical, the officers should not, as a matter of due process and law, have questioned my client until he had spoken to a support person of his choosing. The arresting officers have completely failed at this in the first 2 instances of his questioning, and on the third instance, he was provided the person we know as Donna as a support person. Before going to Donna, I'd just like to take Your Honour to the definition of a support person in the Police Powers and Responsibilities Act. It's at page 6 of my submissions and reads, a support person for a child refers to a parent or guardian of the child, a lawyer acting for the child, a person acting for the child who is employed by an agency that provides legal services, an adult relative or friend of the child who is acceptable to the child. And for a Torres Strait Islander child, a person listed as a support person. Now turning back to Donna. Donna's identity is still unknown. Donna's qualifications are unknown. She is not related to my client, and my client has never met her before. She is not a support person for the purposes of the Police Powers and Responsibilities Act. Further, and more to section 421, Donna was not chosen by my client as his support person. Further again, Donna failed to caution my client about his right to remain silent. Rather, and perhaps misleadingly, Donna advised my client to answer the police questions and to tell the truth. Your Honour, I submit that the arresting officers have failed to accord with due processes pursuant to section 421 of the Police Powers and Responsibilities Act. These processes are well established and understood and must be followed by all police officers when questioning children. These processes are in place to ensure the fairness of suspects in questioning, especially vulnerable suspects such as children. In this case, the police officers have shown a clear disregard for the proper administration of criminal law. Further, the arresting officers have failed to exercise any good cultural judgment. My client's age and cultural background, along with his gratuitous answering to questions in the interviews, would strongly suggest that he did not understand the questions, whilst also suggesting a need to have a support person there. I would suggest to you that had my client been fairly treated, I would suggest that had my client been fairly treated and the correct procedures followed by the arresting officers, my client would not have made the admissions that he did in that interview, in which the Crown now relies. To allow this evidence to be admitted despite the absolute failure of arresting officers to follow these processes would be unfair to my client, whilst allowing unlawfully obtained evidence into the court. There are some serious public policy concerns at play here, particularly surrounding police powers and the fairness of suspect questioning, particularly children. I apply to Your Honour to exercise its inherent jurisdiction to include the evidence of the interview from the police station against my client in accordance with the Island and Bunning discretion.